Hi, this is Kelsey Fikowski, and in this video, we're going to be talking about Roe v. Wade, one of the most controversial cases that's going to legalize abortion. And please keep in mind that as I go through this video, this is for purely educational reasons only, and we're going to be looking at the legal reasonings and nothing else in terms of that, as this comes straight out of the College Board curriculum in Unit 3, as Roe v. Wade is one of the required cases for you to know for the exam. So let's start with the history of privacy. That word, that seven-letter word, is never explicitly mentioned in the Constitution. So certainly we've had cases such as Mapp v. Ohio that say you need to have a warrant before the police come into your house, and they don't. All that evidence that they may collect is subject to the exclusionary rule and cannot be used against you in the court of law. Typically, when we're looking at privacy prior to Roe v. Wade, we're looking at cases involving crime. And the Fourth Amendment certainly is going to be one of those amendments that infers privacy, again, not explicitly mentioning it, but you have the right to remain secure in your own dwelling and that the police need a warrant. So again, that makes sense, but the way that is going to be in terms of interpreting privacy is going to have a fundamental shift in the 1960s and 1970s, where it's going to be not just talking about privacy in terms of being secure in one's home and other places, but one person's own privacy. And again, we're going to be looking at the right of privacy being inherent in our Constitution in the shadows, or what's called the penumbras, of several amendments. So one amendment that you probably are not terribly familiar with is the Ninth Amendment. And in my opinion, this amendment is not emphasized enough in the AP Gov curriculum. But the Ninth Amendment basically says any right not explicitly mentioned or given to you in the Bill of Rights doesn't mean that it's not denied to you. It just means it just hasn't been listed here. So just because we haven't listed them in the Constitution doesn't mean it's denied to people. And as you're going to see in subsequent cases, the arguments that are going to be made is that the right to privacy is in the penumbras of several amendments, such as the Ninth Amendment, as well as the 14th Amendment. And of course, we know the 14th Amendment, the Due Process Clause, it's just so fundamental towards the legal reasoning of many of these cases. So again, privacy is going to make a shift from once referring to just places to also now encompassing both places and people in terms of privacy. So let's get into the actual case of Roe v. Wade in 1973. Well, Jane Roe is the pseudonym of a pregnant 19-year-old who is seeking an abortion, and she's going to claim a right to privacy. And the question is going to become, does the U.S. Constitution protect the right of a woman to obtain an abortion? Again, keep in mind that at this point, privacy was really more or less referring to one's own house, not really towards a person's own specific privacy. But if you go back 8 years earlier, Connecticut actually had a law that criminalized counseling to married people for the sole purpose of obtaining contraception. And that law is going to be declared unconstitutional. And what's so important is that this is going to create the framework for Roe v. Wade to come through. And it's going to utilize several amendments here. The First Amendment, they're going to claim that there is an inherent right to be free from government restrictions. Keep in mind, the Third Amendment, who would have thought the Third Amendment, I mean, this is typically taught as one of the most irrelevant amendments in today's day and age, even in the 20th century, with respect to quartering soldiers. But that amendment in and of itself does talk about and basically does infer privacy. So even the Third Amendment, believe it or not, is actually going to be used for privacy in some ways. Again, talking inherently is going to create a framework for Roe v. Wade amongst several other amendments. We know that the Fourth Amendment is well known as the Privacy Amendment, and then especially the Ninth Amendment with respect to, again, just because these rights aren't explicitly listed doesn't mean other rights not mentioned in the Constitution are denied to you. So this is going to be seen as creating privacy for, again, a specific person, and this is seen as a fundamental value for Americans. So the arguments for Roe, and I think they are very important to point out here because I'm also going to go into the arguments against Roe. But again, you're going to be looking at the First, Fourth, Fifth, Ninth, and 14th Amendment, specifically the Due Process Clause, which has been so fundamental in other cases from Mapp v. Ohio, Gideon v. Wainwright, Miranda v. Arizona, and it's again going to be looking at this implicit right to privacy. So another argument that's going to be made is that unwanted pregnancies heavily affected women, especially in the 1970s and earlier. There was no maternity leave. You could even be fired, actually, for being pregnant, and this could inhibit the career of women. Women were also undergoing illegal abortions that were considered unsafe, again, jeopardizing the life of the mother. And then the question becoming as to whether or not an unborn fetus is protected under the 14th Amendment. Arguments for Roe are going to say, well, an unborn fetus does not constitute, quote unquote, a person here. On the flip side here, arguments against Roe is that, well, there's no right to abortion, it's not specifically mentioned, and that the Founding Fathers, and again, sort of taking an originalist approach here, never intended for the 14th Amendment to extend to abortions. The fetus is a person, according to advocates against Roe, that a person starts at the start of, a person begins at the start of conception, rather, and that the state has a compelling interest to protect its future citizens, and that the rights to privacy, even though they have been established to some extent in Griswold and other smaller cases, is not absolute. That just like the First Amendment is not absolute, you can't just say anything you want, especially, let's say, if it's a terroristic threat. They're going to make a similar argument that your right to privacy is not absolute, that there are restrictions to that. And then they also are going to be making an argument. Again, this is the collective argument. I'm not saying this is the central argument here in Roe v. Wade for those arguing that abortion should remain illegal, but these are some that have been mentioned, that abortion should be left to be decided by the state, sort of making a 10th Amendment argument with respect to reserved powers. But ultimately, the decision is going to be 7-2 in favor of Roe based on the Due Process Clause of the 14th Amendment. And they're going to take apart that word liberty. The idea of freedom is considered a fundamental right to privacy. And as a result, that freedom allows a woman to make her own choice. And the idea of privacy, that a decision, according to the Supreme Court justices, should be made between the mother as well as the doctor. They're also going to utilize that idea of a person in the 14th Amendment, that an unborn fetus does not constitute a person. Again, this is coming from the Supreme Court, and as a result, the Due Process Clause does not pertain to the unborn. They're also going to heavily draw upon the Ninth Amendment, as was mentioned earlier, that you have the reservation of rights to the people that includes a woman's decision. So again, the Ninth Amendment is very, very broad, and it was purposely meant that way to include potential further rights. Keep in mind, although abortion is legal, if you read the majority opinion, and I highly suggest reading the majority, the concurring, as well as the dissenting opinions to really get a full understanding of this, but it is not an absolute right. So the Supreme Court in the majority opinion are going to say, yes, you can make some restrictions. Now, in the first trimester, they're going to argue that the state's interest in protecting its future citizens is not compelling enough to restrict abortion. However, by the second trimester, the state can begin to regulate, but cannot prohibit abortions if restrictions are about the health of the mother. And the third trimester, state's interest is most compelling to protect the unborn, may prohibit abortion, but with the exception of for the life of the mother, that still has to be allowed. So you see that restrictions begin to trickle in the second and the third trimester. So abortion is not absolute. It can be restricted, and certainly if you pay attention to the news, there are a lot of states, especially in the South, that have tried to restrict abortion in a variety of different ways, some of which have been upheld, some of which have been struck down. But again, I very much encourage you to read the opinions involved here, and this is just a somewhat cursory overview of this, and hopefully this gives you a better understanding of how this case was decided.